Folks, please take your seats. 30 seconds to the start of the program. 30 seconds, we're going to start. Thank you.
Good evening. Please take your seats so we can begin. Welcome to the 12th Annual Jewish Law Symposium. My name is Ken Rosen, and it's my honor to welcome you to this incredible event. The Jewish Law Symposium has become an institution throughout the state of New Jersey. It gives us all the opportunity to explore and study the ethics, morals, and values that are the cornerstone of the law. And the topics are always relevant to our daily lives. I would like to take a moment to recognize and welcome the dignitaries that we have joining us this evening, including esteemed members, current and former, of the New Jersey Supreme Court and the judiciary as a whole, our local political leaders who work hard to make New Jersey a better place in which to live, respected leaders and scholars from the Rabbinical College of America, our platinum sponsor, RWJ Barnabas Health, and all of our corporate and table sponsors. And of course, our presenters and panelists this evening, who are the Honorable Virginia Long, Rosemary Alito, Neil Mullen, Karen Kessler, and Rabbi Shlomo Yaffe. They are all thought leaders and at the top of everyone's go-to list for the subject this evening. Karen Kessler currently serves on the board of directors of Northfield Bank Corp., Inc., on the board of Sinram Corporation, and is the only non-attorney committee member of the New Jersey Advisory Committee on Judicial Conduct. 2 years ago, she accepted the Thurgood Marshall Award of Excellence for Outstanding Achievement. Retired New Jersey Supreme Court Justice Virginia Long is now a member of the Fox Rothschild firm since March 2012, after having spent 15 years on the appellate court and 12 years as a pivotal player on New Jersey's Supreme Court. Justice Long was recently appointed to the Supreme Court Special Committee on Attorney Ethics to study the new ABA rules on professional conduct. Ms. Alito, in 1999, was honored with the Trial Bar Award for Outstanding Performance as a Trial Attorney. That was by the New Jersey Trial Attorneys Association. I beg your pardon, New Jersey Attorneys for, well, I don't know. She has served as lead counsel in the successful defense of class actions under ERISA and the LMRA, involving multiple employer welfare and pension trust funds and trials of class actions challenging termination of retiree medical plans. Neil Mullen is a frequent lecturer on employment law matters, has spoken at state and federal judicial conferences, and is a regular speaker for both the New Jersey State Bar Association Labor and Employment Law section, as well as for the National Employment Lawyers Association. The Jewish Law Symposium was founded by Rabbi Shalom Lubin, Executive Director of the Chabad of Southeast Morris County. This past May, Rabbi Lubin and the Chabad celebrated at an inaugural gala, 15 years of service to our community. And with that, I think we shall begin. Rabbi Yaffe? I beg your pardon, we're going to show a video first. I apologize. Highlights of the inaugural gala.
Well, when the rabbi asked me to host tonight, he said, listen, John, there's going to be 3 requirements. Number 1, you got to learn how to pronounce the word Chabad rather than Shabbat. I said, Rabbi, that's not a problem. I was born right up the street from Highland Park.
Just last week, I celebrated my bar mitzvah with Chabad and Rabbi Mendy. I'm proud to be a part of the Chabad community and to look forward to my continued relationship with Rabbi Mendy and the Chabad organization.
I became a grateful beneficiary of the scholarship fund, which has allowed me to pursue the dreams I had since I was a young girl. My goal is to be a clinical neurologist, perhaps with a subspecialty in pediatrics, with an active role in research. And I give you my word that I will use the gifts that I've been given to help change the lives of every one of my patients one day.
And to each and every one of you, I just want to say thank you. Thank you for allowing us to do everything we've done up until now. And thank you so much for the trust and the encouragement and the vision we share to change this world for the better. One person at a time, one soul at a time, one individual at a time.
As my father got older, he would visit him virtually every day in the assisted care place. And I would go there, and I would be so proud of myself getting there. He said, oh, you just missed the Jewish guy. I said, which Jewish guy? He says, you know, Shalom, the guy you can't say no to.
I have witnessed the impressive growth of this Chabad. The annual Law Symposium was established where every topic deals with Jewish values and ethics. The Thanksgiving dinners are delivered to the homebound, no matter what religion. The Senior Learning Group has expanded so much that one has to arrive early in order to get a seat.
Chabad is the spirit of Judaism as Hashem meant it to be observed with love and compassion to all. That is the mission of Chabad, and I am proud to be part of that mission. On this night, I wish continued success to the Lubins and the work of Chabad. Each day, Chabad changes our destiny.
Shalom aleinu mi'am kol Yisrael. Yaseh shalom, yaseh shalom. Shalom aleinu mi'am kol Yisrael.
Ladies and gentlemen, we are pleased to welcome New Jersey Supreme Court Justice Janie LaVecchia, who will introduce our 2018 featured presenter.
Good evening, everyone. It is my absolute pleasure to introduce a woman who I believe is ideal to the task of being our featured speaker tonight. Justice Virginia A. Long is well suited to focusing a discussion about the subtle and not so subtle dilemmas that can arise in society's movement toward the elimination of inequality and discrimination in the workplace. She has walked that walk. Let me tell you a little bit about this trailblazing woman. Justice Long has shown how a woman can break into what was a male-dominated profession. Not only did she do that, she showed how well a woman could perform alongside men in such circumstances, and she rose through the ranks of her profession to achieve the very heights that it has to offer. Justice Long has had a distinguished 35-year judicial career, the last 12 years of which were capped off with her service on the New Jersey Supreme Court. She did that until the Constitution required her to step down because of the mandatory age of retirement. The Constitution says 70 is too old to serve. Old my foot. Virginia had lost no vibrancy whatsoever. And she absolutely loved the court, and most certainly was not ready to step down. I don't know who was more disappointed about her reaching the age of retirement, her or those of us that she left behind on the court. I think it's close. I know how much we miss her on the court. And I say it's close because I now sit on the bench where Virginia used to sit, and I see dug into the wood on the bench fingernail claw marks that I just don't recall being there before Virginia had to leave. The point is that we just miss her, and we still quote her more memorable lines from time to time during our private conferences. She had so much experience that provided the fodder for her wit and wisdom that so helped us as we worked our way through the cases that the court has to decide. She is the author of 3,000 opinions that she wrote during her judicial career. While she was a judge, she served in every division of the Superior Court. Along the way, she was the first woman appointed a presiding judge of our Court of Equity, the Chancery Division. She also was a distinguished member of the Appellate Division, rising there to be a presiding judge as well. Once on the Supreme Court, Justice Long wrote on the broadest array of subjects that one could possibly imagine. Her legal acuity and her writing skill led her to make so many contributions to the law's clarification and improvement. When the time came for her last sitting with us on the court, we recognized her for her progressive vision, so necessary for a court of last resort. That is, after all, the challenge of the law. It must remain responsive to new needs. Her elegant opinions would build on existing precedent when confronting new legal issues, so that, as one of us said, it was Justice Albin, when she left, the edifice of the law as she left it would remain a living monument that addresses the realities of the times. What a fitting monument to her. She was a force on our court and also off of it. Although the sobriquet notorious VAL has not been conferred, her admirers are many, to be sure. But she's not one to ever have become enamored of her own press, which, by the way, has only reinforced that she is one of the most respected and beloved jurists in the state. When she retired from the judiciary, the New Jersey Law Journal wrote an editorial that praised her service and called her a woman of profound humanity and uncommon wisdom. Her ability to see how the law would ever evolve and must evolve to address new problems comes no doubt from her broad legal experience and legal knowledge. But it also comes from her unquenchable interest in all things. Between her full and active life with her husband Jonathan and her family, Virginia somehow always managed to stay ahead of most people in being informed of things, all things, big and small. Whether it was cultural or newsworthy, her interests are wide and her enthusiasm infectious. Unsurprisingly, her reactions to new ideas are invariably generous in spirit. She is and always was on the cutting edge in her thoughts and, as it turns out, in her life. I recently came across an old newspaper clipping from 1976. My mother had sent it to me. I was about to start law school that fall at the Rutgers Newark School of Law. The article pointed out that the most visible change that would be happening in the law was not going to be the newly approved lawyer advertising or storefront legal clinics or the use of credit cards for the payment of legal fees and costs. Instead, this article said it would be the people who practice law that would be the most significant change, because women were charging into the law in jobs, on judges' benches, and filling the classrooms in big ways. Before 1972, there were only 374 lawyers in the state of New Jersey that were women. By 1975, 3 years later, that number had risen to 1,100 out of almost 19,000 lawyers. The article closed after citing those statistics by pointing to two rising stars. One was Ann Thompson, who was making headlines as being the first black female prosecutor appointed in New Jersey to head, in fact, the Mercer County office. But then the article's closing paragraphs were devoted to the state's newest appointed judge, state banking commissioner and former director of the Division of Consumer Affairs, Virginia Long. Law, it seems, was always the right fit for the new judge to choose as her life's work. She was quoted in that article as saying that she never considered herself limited to women's professions due to a confidence that she attributed to her parents and their belief in her and any woman's ability to do any work that she set her mind to do. The article proceeded to recount the many accomplishments that the new judge had achieved since her graduation from law school, also the Rutgers Newark School of Law, in 1966. I have to say that my mother was right to send me that article to inspire me as I was about to set off on my own legal education. Judge Long inspired me then. Justice Long still does. It was a thrill and privilege for me to be able to sit on the bench alongside of her. So tonight, it's my pleasure to introduce to you proudly my colleague, Justice Virginia Long.
Compatriots at the bench and bar. First, let me thank Justice Lavecchia for her kind words. Janie, I'm keeping it for my funeral because I am never going to do better than that. I would also like to thank Rabbi Lubin for asking me to deliver this keynote address, and especially for the opportunity to share the dais with the luminaries on the panel, whose insights I am so looking forward to hearing. Now, we all know that the outing of Harvey Weinstein by Jodi Kantor in the New York Times a year ago was the proverbial shot heard round the world. She reported years of sexual misconduct by the movie mogul upon women in his workplace and subject to his power. The outpouring under the hashtag #MeToo has been breathtaking, a tsunami of its own involving some of the most famous institutions in the world. Boatloads of perpetrators have been outed, careers ended, reputations in tatters, and the women just keep on coming. And some commentators suggest that we have turned a corner on sexual harassment. Well, I'm not at all sanguine about how much Me Too, standing alone, is going to matter in the long run in a world in which the sexual harassment of women in the workplace is so deeply rooted in history that there is no period during which it has not flourished. And history matters. As Simon Schama tells us, we look at history not to revive the dead, but to inspire the living. It is part of our cultural bloodstream, the secret of who we are. We cannot chart our course unless we know what has brought us here. As a wag once said, history doesn't say goodbye, it says see you later. So what is the history of which I speak? Well, the oldest recorded account of sexual harassment in employment is a papyrus on display in the London Museum, written about around 1200 BC. It involves artisans in the Valley of the Kings and reports that the chief master craftsman sexually harassed women working on the job site. The Old Testament includes workplace sexual harassment allusions. For example, Ruth and Naomi are saved by Boaz from what he believed to be the potential predations of the harvesters. The first litigation involving sexual harassment took place in 1343, when Elizabeth de Huisted, who had been contracted to a cutler, left the job because of his coercive behavior. He sued for breach of her contract and won. In colonial America, female domestics took out an ad in the New York Weekly Journal condemning harassment by their mistresses' husbands. Sexual coercion of women was an entrenched feature of slavery, and although there were critical differences, the burden borne by free domestic workers in the North during that same period was enormous. Reformer Helen Campbell wrote in 1887 that household service has become synonymous with the very worst degradation that can come to a woman. During the Industrial Revolution, sociologist Mary Belarsek tells us that seamstresses living in boarding houses to follow the work were pressured daily by their supervisors for sex. Their jobs depended on cooperation, and because in the 19th century purity was everything to true womanhood, the factory girls were in a double bind. If people knew that sex occurred, even if it was forced, their lives, reputations, and marriage prospects were ruined. Upton Sinclair's 1905 expose, The Jungle, shone a light on the women in the meatpacking industry who were regularly subjected to horrific sexual coercion by their male bosses, as were Jewish garment workers and the women in Italian canneries. So up to that time, sexual harassment maintained a predictable form: men in power seeking sexual access to women in their employ. The form remained stable for the next few decades, but changed during World War II when Rosie the Riveter, who only earned 50% of what her male counterparts were paid, came on the scene. She was often isolated by male workers who feared that she would replace them or usurp some of their power, and that in turn resulted in classic harassing conduct, including mocking, catcalls, and undermining, always with sexual overtones, but not seeking sexual access. That, of course, was a foreshadowing of the 1970s and onward, when women began to break into a series of traditional male jobs. The Ford Motor Company is the paradigm. The jobs were the best that the women in Detroit had ever had, but fellow employees on the line made it unbearable. They commented on the women's bodies, they leered, they simulated sex acts, and carved pictures of sex organs into the lunch tables to demonstrate their contempt and the women's outsider status. And this went on for decades. In the 90s, Ford was sued by the EEOC and paid $22 million in settlement. As an aside, the legal profession did not go unscathed. Despite being admitted to practice in every jurisdiction by the turn of the century, by 1963, a Harvard Law Review survey reported that women were absolute outsiders, the very least wanted recruits in firms of every size and specialty, regardless of their law school performance. The notorious RBG was first in her class at Columbia Law School and couldn't get any job at all. Most law firms said, "We do not hire women here." That was my generation, but that is another story. Now, you might be saying, well, yes, but that was discrimination. It was not harassment, and you would be technically correct. But we know today from repeated empirical studies that numerical scarcity allows the seeds of harassment to take root and amplifies the risk of such conduct, and the proof is in the pudding. As elsewhere, women have repeatedly reported being sexually harassed in law firms. Now, a watershed in the long history of sexual harassment of women at work occurred in the 1970s. Women who had rarely talked openly about sexual harassment began to share their personal stories at consciousness-raising sessions. Indeed, such a session at Cornell is where Lynn Farley coined the term sexual harassment. In 1976, Red Book magazine did a survey of 9,000 women. 92% identified sexual harassment as a problem in their workplaces. Time magazine noted that as many as 18 million American females were harassed sexually while at work in 1979 and 80 alone. The women's stories ran the gamut: professional, white-collar, office, factory, all ages, appearances, races, and religions, all forms of harassment. And there was, for the first time, some sense of the damage done by the practice, the inherent power imbalance that made women feel they could not rebuff unwelcome male attention, caused victims to internalize their guilt over somehow bringing it on themselves. Anxiety, sleeplessness, anger, humiliation, depression, and despair, and all that time, women were afraid to complain for fear of being ridiculed or blamed, with a resultant reputational or job loss. What is important is that all this was happening over a decade after Title VII of the Civil Rights Act of 1964 had specifically outlawed discrimination based on sex. Had the judiciary embraced the notion of sexual harassment as an expression of discrimination, Title VII might have been the beginning of the end of all this. But as Yale law professor Reva Siegel points out, courts simply refused to acknowledge that sexual harassment had anything to do with employment discrimination. They said it was just something that happened at work, or alternatively, it was natural and inevitable and nothing that the law could reasonably expect to eradicate, and it couldn't be based on sex because it could happen to anyone. Thus, for many years, the efforts of feminist litigators focused on convincing courts that sexual harassment is a form of sex discrimination under Title VII. Feminist theorists, particularly Catherine McKinnon, argued that most sexual harassment is really not about sex at all, but about power. It was McKinnon who was the first to theorize that there are two distinct types of harassment, including quid pro quo, where career decisions are linked to sexual access, and hostile work environment, which is pervasive sexual conduct that is severe enough to affect the job performance of the target. Those categories were ultimately accepted by courts and remain part of our law today. But it took a decade after Title VII was enacted for a federal court to actually recognize sexual harassment as a form of sex discrimination. That first case involved Diane Williams and, ironically, the Justice Department where she worked. Her married boss made sexual advances. She protested. When he kept it up, she filed a complaint, and she was fired. She sued, and in 1975, a federal judge finally recognized that Title VII protects an employee from quid pro quo sexual harassment. At first, the law intervened selectively. Most of the initial successes were quid pro quo, and some courts actually limited remedies to that form. But in 1980, the EEOC recognized sexual harassment as discrimination, both in its quid pro quo and hostile work environment iterations, and the Supreme Court followed suit in Meritor Savings v. Vinson and cemented it in Harris versus Forklift Systems. Those cases established that Title VII prohibits the creation of a hostile work environment based on gender, and that is an entirely separate claim from quid pro quo harassment. And the legal victories started piling up. But do not think for a second that those victories came cheaply. It was a long, hard slog. Initially, most cases were lost, and those that were won were costly in every way, deeply venomous, with the so-called nuts and sluts defenses reaching fever pitch. They were lengthy and expensive. Some took years and years and sparked counter-defamation suits. Plaintiffs were often belittled in the courtroom, and judges imposed their own visions of human nature to minimize the damage done. Nevertheless, it has been clear for 40 years that gender-based sexual harassment is actionable sex discrimination under Title VII and its progeny. And yet, the practice continued unabated, and today we find ourselves in a hot stew of sexual harassment allegations by women. The EEOC reports sexual harassment complaints by women have been on a continuing path upward. And according to a report in the New York Times, women at the Ford Motor Company are reporting the exact same conduct that was the subject of the earlier cases. And in August 2017, yet another $10 million settlement was reached with Ford. That is, incidentally, history seeing us later. So it seems that outlawing sexual harassment and even meting out individual punishment is not enough to quell the practice. So what do we need to do? First, we need to acknowledge our history and the longevity and deep roots sexual harassment has in our culture and in our psyches. Next, we need to stop saying everything is fine. A 2017 Harvard Business Review survey reports that 2/3 of women lawyers have witnessed or experienced sexual harassment at work. 2017. Then we need to follow the lead of social scientists and cultural historians who study the field. They tell us for sexual harassment in all its forms to end, that there has to be a recalibration of the power imbalance in our institutions, which denies the equal worth of each of us, and a climate shift that communicates absolute intolerance for the practices of sexual harassment. So what are those power dynamics that they're talking about? Well, women still make 80 cents on the dollar, meaning they work from January 1st to March 15th for free. Only 6% of Fortune 500 CEOs are women. Although women lawyers make up 45% of firm associates, they only make up 20% of partners, 17% of equity partners, and 4% of management. Most alarming, within the last few months, both the ABA and the International Bar Association have reported that both nationally and internationally, the number of women in leadership roles is declining rapidly, and women's clout is on the wane. Again, that is just the opposite of what the experts argue should be taking place. Thus, it falls to those who are now in power to exert a downward force on workplace sexual harassment by creating an equitable and just workplace. Firms need to decide who they are and who they want to be, and that means identifying the organization's core values, modeling them, and living by them every single day. On a granular level, there should be zero tolerance for sexual harassment in any form, which means supporting complainants, utilizing 21st century reporting technology which maintains anonymity, protecting complainants from retaliation, improving transparency and accountability, and fostering a shared sense of responsibility for ending harassment in the workplace. The message must come from the top, and it has to be believable. It will not be believable if a firm fires a harasser and then, as the Wall Street Journal recently reported, helps him to find a great new job. It will not be believable if he receives a golden parachute. In addition, firms should no longer consider diversity policies and training to satisfy their obligations. Indeed, a Harvard Business School study of 829 companies over 31 years concluded that diversity training had no positive effects on conduct in the workplace and some negative ones. To be sure, it has inoculated companies from lawsuits, but that's about it. And it may not be the training itself that is the problem, but the attitude of management understood by all that if we just check off the training box, our work here will be done. In terms of power sharing, firms need to scrutinize their hiring practices. For women to accede to the halls of power, they need to be hired. Now, we know from a report in the American Journal of Sociology that where job candidates are equal in every single way, mothers are 37% less likely to be hired than childless persons, and fathers face no such hostility. With respect to advancement, we know from social science that women, even in the most egalitarian homes, are working a total second shift and doing twice as much of the detritus of child rearing as their spouses. A recent year-long ABA survey concluded that the disproportionately small number of women holding power positions in firms is in part because women are leaving, and that one important reason is a lack of flexibility in the schedule, which makes it nearly impossible for them to do all of the life jobs they are allotted. Now, I know most firms say they have flex programs, but if they really are the road to the door, or if the rainmakers in the firm do not assign work to flex timers, or if so-called mentors whisper in women's ears, "Don't do it, it's career suicide," those programs are more imagined than real. Likewise, firms must evaluate job allocation and pay equity, and this is not a financial issue. According to several ABA surveys, The second significant reason women are disaffected is that they feel unappreciated and disrespected because their opinions are not valued, they don't get the plum assignments, and they make less money than the man sitting next to them. Now, I know there are people out there who are shaking their heads and saying, well, that's not us. But I would like to point out one more aspect of the same ABA survey, a finding that managing partners in firms think they are doing a lot better to advance women than the women in the firms think they are. Again, this searching inquiry must come from the halls of power. This is not an HR issue. Let me say that again. This is not an HR issue. It is an issue for the boardroom. And we need to do this not just because it's profitable, and it is. We know diversity pays in every conceivable metric, and we know litigation costs and judgments and discrimination and harassment suits are astronomical, but there's a more important reason to do so, and that is this. In exchange for our privileged status as lawyers, we have a moral obligation to help create ethical, fair, and just workplaces in which there is a proportional sharing of power and every individual is respected. So will all this bring about an end to the sexual harassment in all of its vile iterations? Some say no, that human nature cannot be tamed, that we are impelled by the same life forces as those who went before us, and that we are bound to repeat the mistakes of the past. I can only say that scholars and historians who study the field say yes, that if the culture in our institutions changes, sexual harassment will be a thing of the past. Will it be hard? Absolutely. But what thing of real value is not hard to achieve? I know history tells us we should be wary, but I am still optimistic. The poet laureate Seamus Heaney put it this way: history says, don't hope on this side of the grave, but then once in a lifetime, the longed-for tidal wave of justice can rise up and hope and history rhyme. We can choose not to be defined by our history, but Harvey Weinstein and Me Too are not going to do it for us. We need to do it for ourselves. At least that's the way it seems to me. Thank you.
Wow. Thank you, Justice Long, for your wonderful, thoughtful, and brilliant words. Thank you very, very much for raising awareness on this topic. Welcome, everyone. Thank you so much for joining us at our 12th Annual Jewish Law Symposium. It's great to be here, great to have everyone here, and great to get to the wonderful panel that we have just in a moment. A couple of housekeeping notes. First of all, there's no rush. It's only 7:15. This time last year, Paul Fishman was just getting started. And at the end of the evening, of course, we do have our honey glazed challahs, which will be given out at the end of the program. So we'll get comfortable and have a wonderful time together. A couple of thank yous. I want to thank all of our corporate sponsors, all of our table sponsors, all of you who have helped us in so many ways, especially Ken Rosen for the wonderful introduction and all you do for us. Thank you so much. Thank you. Special thank you to my father, who flew in from Chicago. First time he's here at the symposium. Give it up for my dad. My brother Mendy, who did so much work, my wife Arona, my daughter Rivka, whose birthday is tonight. Happy birthday, Rivka. You see, I told you I'd make you a party, right? And for all of you for being here. You know, the time of year we're in now during Rosh Hashanah and Yom Kippur, the days of awe, are really a time of reflection. And I just want to pause for a moment on a more somber note to remember a few longtime members of our advisory board and instrumental members of our Jewish Law Symposium family that passed away this past year. Scott Mayer of blessed memory was a sponsor of ours for many, many years. Bob Field loved attending our program. Mark Tepper was on board from the very beginning. And Barden Levavi and David Schechner from the Tuesday Talmud group were truly an inspiration to us. And may their memories be a blessing, and their inspiration continues to live on in all of us and all we do. So thank you very much for being here and being a part of it. You know, they say the difference between a Jewish pessimist and a Jewish optimist is that the Jewish pessimist looks around and says, you know, the world's falling apart and everything's terrible. And you look at Washington, what a mess, and foreign policy around the world, despots and dictators, it's terrible. And Israel, oh, don't get me started on Israel. Things are so bad, the pessimist says, they couldn't possibly get any worse. And the Jewish optimist says, yes, they can. Yes, they can. You know, this past year, it's interesting. I came up with this relevant and timely topic addressing harassment many months ago. And at the time, I had an inkling of, will it still be timely in September? It's still timely in September. And every day I'd say, well, this will be a good clip to show someone of prominence, of stature, that was taken down by these allegations. And then a week later it was like, well, we could do this clip instead, and this clip instead, and it doesn't stop. And we have, just this week, it's Les Moonves and Jeff Fager. And it's really one thing after another. But, it's a complicated topic. And it's a topic that has a lot of nuances. It's a topic that's hard to necessarily talk about with each other. We all come from different places and have differences of opinion on the matter. And tonight I'd like to get into it a little bit, and I'm very happy to have the panel we have to discuss some of the nuances related to whistleblowing, to standing up and speaking up on matters that are difficult to talk about, to get into the topic of NDAs, non-disclosure agreements. Do they have a place? Do they not have a place? Should they exist? Should they not? And most importantly, as we'll wind down the program later, the topic of second chances. It's a time of repentance, days of awe, Yom Kippur is approaching. Do we believe in repentance? Do we believe in forgiveness? How does that relate to the Me Too movement? What do you do with people that have done terrible things? We'll talk about that and glean the insight from our wonderful panel, Rabbi Yaffe, Karen Kessler, Neil Mullen, and Rosemary Alito. I'd like to begin with a video clip. This is from LA, so it's not a New Jersey story. It's from a few months back, but it kind of puts together all of the issues that Justice Long has discussed related to a real-life news story. Let's roll the clip, please.
From the largest district attorney's office in the nation, where 1,000 lawyers are sworn to prosecute criminal behavior, an email to DA Jackie Lacey, an alarming allegation. I am reporting a crime of sexual assault by one of your deputy district attorneys. This email details how a deputy DA became a whistleblower, alleging sexual harassment of a female coworker by a male supervisor. What's more, in court documents, the whistleblower says that raising the alert has made her a target, writing that, I have cooperated in a County of Policy and Equity sexual harassment investigation, and because of my cooperation with that investigation, I have been retaliated against. Los Angeles County District Attorney Jackie Lacey denies retaliation against the whistleblower and bias in the plea deals.
We checked that out up and down and discovered it just wasn't there.
About sexual harassment in the workplace, Lacey says, no question, it exists. She was once a 20-something lawyer facing the men.
As a woman in the office, you dealt with it by trying to ignore it, changing your clothing, hoping that it would stop or go away.
You personally?
Well, sure.
Then the Me Too movement, from Hollywood to the state legislature.
Women aren't going to be silent any longer. They're willing to come forward, and this legislature will investigate.
At the DA's office, Lacey says reports of sexual harassment have increased. As for the actions of the whistleblower in reporting it, she praises that.
That is courageous to do that, because you could, in fact, ignore it, which so many people have done. It's been right under their nose, and they've ignored it and gone on and not done anything.
There you have it, folks. There's the whole topic in a nutshell. But I'd like to begin by asking Neil. Neil, you're a plaintiff attorney. You've been representing people for many years. Why is this such a hard thing for people to do? Why is it hard for people to stand up and talk about things that have happened to them or to others within their company, within their firm? Why is this all coming out now, and why has this been something that's been pent up for so long? Neil.
Oh, that's a lot. Let me start with something Justice Long said. The problem of sexual harassment, as she detailed, is a problem of patriarchy. It extends back thousands, maybe tens or hundreds of thousands of years. Women have been second-class citizens and third-class citizens across the globe and across time. That's why it's hard. We've created a legal system that has significant impediments to women asserting their rights against discrimination. I can do this narrowly and broadly. The Supreme Court of the United States, unfortunately, has repeatedly upheld mandatory arbitration. As a justice of the Supreme Court recently pointed out in dissent, 53 million Americans have been forced to sign mandatory arbitration agreements so that if sexual harassment occurs, women are silenced. Arbitration proceedings that they're forced to enter into when they sign up for employment are secret. If you look at the rules of JAMS End Dispute or AAA, they require the arbitrator to maintain the confidentiality of the proceeding. And when women sign up for corporate employment, they have to sign in advance of employment often confidentiality, secrecy, and non-disclosure agreements. So secrecy is good for sexual assaulters and harassers. Secrecy is good for Harvey Weinstein. Secrecy is good even in religious institutions where the sexual assault of children occurs. Secrecy helps this problem get worse. Now, Justice Long said, and I thank Justice Long for that very profound introduction. Thank you. Justice Long said it's a problem not for HR, human resources, but for the boardroom. I think that's important and profound. HR is always staffed by people who are caught between a rock and a hard place. We've represented, and even have published decisions representing women who are heads of HR departments. When they complained of discrimination and harassment, they were retaliated against and fired.
Who do they complain to?
Exactly. Good question. Here's the boardroom, though. Listen to this. Today's New York Times, the Moonves case. This is back in July after 6 women are reported to have suffered severe, serious sexual harassment. This is what happened in the boardroom. Here's what one board member named William Cohn, who you may remember was the defense secretary under Bill Clinton, said. We're going to stay in this meeting until midnight, if we need to, until we get agreement that we stand 100% behind our CEO, and there will be no change in his status. Here's what another director said, Arnold Kopelson, an 83-year-old producer who won a Best Picture Oscar for Platoon. He said to the board of directors, I don't care if 30 more women come forward and allege this kind of stuff. Les is our leader, and it wouldn't change my opinion of him. Now, that's the boardroom. That's not the HR department. So we get back to another thing the justice said. The composition of the upper echelons of corporations are overwhelmingly male to this day. The compositions of our state legislatures only have 19% women. If you add up the Senate and the House, there are only 19% women in our Congress. Mexico just voted 50% of its legislature to be women. The boardrooms are dominated by men. The men are in a men's club. Have you been in a locker room? It's for real. I'm a guy. I know what happens. So where do you go? How do you solve the problem? If you're a woman and you complain, what do you do?
We'll get there in a moment. Rosemary, give us your take. You've been in the employment world for a very long time, chair a wonderful, large practice. You're dealing with these issues every day. What's your take?
Well, the question was, why do people find it difficult to come forward? I think in today's world, no one should find it difficult to come forward with a complaint of sexual harassment, whether a man or a woman. Every responsible company has a policy, has a procedure for reporting complaints of sexual harassment. The penalties for retaliating against someone who complains about harassment are severe. And not just legal penalties, business penalties today are severe for any company that permits harassment and any company that retaliates against someone who reports harassment. And I agree, that's the way it should be. And the business community today, in many ways, is imposing even harsher penalties on companies that don't have the kind of culture that Justice Long spoke about, or at least aren't striving towards the culture that Justice Long spoke about. In the legal profession, we see major corporations imposing all sorts of requirements on the law firms that represent them to ensure that all of the law firms that they do business with represent their corporate values. Microsoft Corporation recently announced that it was looking for all of its vendors to have the same paid family leave that it provides. And again, I think Justice Long was spot on in identifying what are some of the reasons why women fall out of the workplace and fall out of the upper echelons of law firms. It's because of their family obligations. So it's not just complying with the law, it's a mandate of success in business today.
Karen, help us out over here. You live in the world of public relations. So you have two types of whistleblowers, and we'll use that word as we relate to the topic of sexual harassment. You have someone speaking up about themselves, and then there's someone speaking up about the culture that's going on within their company, or speaking up for something that's happening to other people in the firm. What are the risks involved? Someone calls you up and says, I know this dirt, I know what's going on with my company, I'd love to stop it, but what's going to happen to me? What happens to my future career? What do you say?
It's tough. And listen, nobody wants to be Linda Tripp, and that was sort of for the longest time. That was the image in the public mind of what it meant to be a whistleblower. It's not that way as much anymore, but it's still tough. And it's very tough for people to think about when you do want to report this, where do you go? And you have to have, am I allowed to use this word, rachmanis? You have to have, in this crowd, am I allowed to say that? You have to have rachmanis for the people that are the HR people, because they did not go up and learn their profession to be sex police. And now, all of a sudden, they're being told, you have to educate, which some of them are able to then hire firms like Rosemary's to come in and educate, or some of the firms that are out here today. They have to police, they have to anticipate, they have to punish, they have to reward, they have to communicate. They're not ready to do any of those things, in my opinion, from the companies that we've worked with, and that's a huge problem for people that want to come forward, because that's not a place of safe harbor for most of them, because those people are not prepared to talk about it. And that's a really tough deal for people that want to come forward.
When someone comes to you and says, I want to speak up, but I'm worried about my future career, what would you tell them?
Well, usually they find a lawyer first, and the lawyer finds us. It's usually how it works. But it's, it used to be, listen, it used to be that all the time, the women that came forward were told that if they had a credible case, how much money, and you're getting out of here, and your career's over, and go home and sit on your money, and that was the end of their careers. That's what it was. Now what happens sometimes is that when it's credible, the men are told, you're getting out of here. But we often are told, see how you can frame this so that it doesn't look like he's leaving for the reasons in which he's leaving. Well, when he's being told to leave and people are not told why he's leaving, then that's a chilling effect on all the other women that have the same kinds of stories and have more in those kinds of operations. It's very tough. It's very tough. And listen, I will say, I know we're supposed to talk on a legal level and not on a personal level, but there's not a woman that's sitting out in this audience today, especially those that are not somewhere near the age that I am, that can't tell you that this started for them when they were in their 20s and extends to them even today. We all have those stories. There's not one of us that hasn't been impacted by this. Correct?
Oh, that's true. And what we want to end, and which hopefully we are ending, is that women of my generation felt like you just had to deal with it. And the women of my generation, to succeed, dealt with it. And that's changing, and that attitude should be totally eliminated.
It's
that
moving.
we all agree on.
I don't know if it's going to eliminate in our life, but it's going to move. Hopefully it's going to move.
Rabbi Yaffe, let's ask you over here. The Jewish perspective, Jewish law, we're talking about whistleblowing, we're talking about people standing up. Is there a moral obligation for a person to be a whistleblower? Does Judaism or Jewish law, Talmudic law, consider it to be an obligation for someone who's aware of other people in their workplace being harassed, being hurt in whatever way it is? Can you say, last year actually we had a discussion about medical ethics, and we used the principle of Chayecha Kodman, that your own life comes first. And when it comes to saving lives, you're allowed to save your own life before saving someone else's. Can a person within a firm or a company say, this is my career, it's my life, I don't want to get involved. I don't want the headache, I don't want the hassle. I know stuff, but I wasn't asked, I'm not going to offer. Rabbi.
So first of all, there actually exists an obligation, even before we get to the argument that sexual harassment is far more serious than the first point. But there's a concept of hashavat aveda. Now, we often think about that if giving back means to return a lost object. And we often think about that in the context of if you find someone's wallet, so find the license and give it back. But in truth, we're obliged to make sure that someone isn't suffering a loss. The obligation to speak out about doing business with someone who may swindle you is hashavat haveda. The obligation to warn people against buying shoddy merchandise is hashavat haveda. All the more so when we see two things with regards to what sexual harassment usually deals with. First of all, that the Talmud is replete with allusions that suffering, embarrassment, shame, insult, denigration is worse than financial loss. No, it's even if someone was going to lose money, if I don't tell the truth about the dishonesty or perhaps the discrimination within the workplace where I'm not paying someone what I should pay them, I'm obliged to speak out. This isn't saving your life, because even if you're retaliated against, presumably this isn't the branch of the New Jersey business world that gives you cement shoes, okay? So you're not going to lose your life. You may have to find another job. This is an absolute moral obligation, all the more so when we're dealing with insult, shame, embarrassment, denigration, which the Talmud clearly says in multiple places is worse than losing money, because you can't ever replace that sense of dignity, that suffering. And the Talmud compares it metaphorically, but in a very powerful way, to murder. And on top of that, if you're actually dealing with the type of sexual harassment that Justice Long spoke about, this where there's actually pressure for sexual access, so any kind of forced sexual access, the Torah is quite explicit. It says it's literally the same thing as murder. There's a person that rises against their fellow to kill, to take their soul, so is this matter, to the extent that saving someone from a genuine sexual assault is considered to be the same law as saving someone from murder. If I see someone attempting to murder someone and there's no other way to stop them other than to kill them, I must kill them. And if I see someone sexually assaulting someone in the full sense of the word, and there's no other way to stop them except by killing the assaulter, Jewish law mandates that I kill the assaulter. So this is a very, very big deal. Granted, not every assault rises to this level, but there's a continuum, and Jewish law recognizes continuums. So anything that involves the sexual exploitation or denigration of another human being, from the perspective of Judaic law, is considered far more serious than the monetary savings, the saving of someone's property that I must speak up about, no matter what the consequences. All the more so when you're dealing something which shades to the level of gross physical assault and murder, and certainly in terms of the emotional costs. As a pulpit rabbi, you work together with counselors, and the costs of this kind of abuse are innumerable, and I think several of our presenters mentioned this idea of dealing with it. But what cost did that dealing with it come? And so I would say that in this case, there's no question that you have to blow the whistle, and
You have the moral obligation.
We have this belief that in the end, our sustenance comes from the Almighty. You have to have a little bit of faith and blow that whistle loud and clear.
Okay, very good. Couldn't agree more. Now, Rosemary, let me ask you a question. I've spoken in the past year to a lot of employment attorneys, and they bring up a disturbing fact. I don't know what the numbers are, the percentages, and I'm interested in hearing what you say, of disgruntled employees that aren't happy or feel that they're on their way out of a job and raise certain claims of questionable validity, hoping for some sort of parachute to take them out. It's an issue. Let's put it right out there. This is an issue people mumble and murmur about. What's going on the inside? That it does exist. How is it dealt with? And give us your take, please.
Well, I think just like any kind of claim, there are some very serious, very legitimate claims of sexual harassment, and they're dealt with one way. There are manufactured claims of sexual harassment, just like there are manufactured claims of personal injuries or any other kind of claim, and they are dealt with differently. It creates tremendous issues in dealing with these because you can't assume, just in the past, you can't assume that everyone making a claim is lying or making it up or has some other ulterior motive. That's totally unfair, and I think we're getting past that. But we also, at the same time, can't let the pendulum swing completely in the opposite direction, where we give total credence to every complaint of harassment that's made because some of them are fake.
Neil, I'd like you to respond to that.
You know, I've read hundreds, maybe thousands of cases published and unpublished decisions of courts across the country in my 38 years. And I don't recall a case, my partner Nancy Erica Smith is here, where a judge ruled that a case of sexual harassment was manufactured. I've seen decisions where judges say it doesn't rise to the level that the law has imposed for sexual harassment. I've certainly seen federal judges, mostly men, find that. But, you know, I'm racking my brains. I suppose there's some case out there. And let me say this. In our 38 years, we've handled hundreds, maybe well over 1,000 cases of sexual harassment, maybe several thousand cases. And I can remember only two circumstances. We vet all our cases. I like to think the courts and the lawyers know that about us. We examine our cases with great care. I've only found two cases that we took that we later realized the woman was lying. In both cases, it turned out there was a consensual relationship that went south, and the woman then turned it all around and said sexual harassment. Well, we found indisputable, in one case, videotape proof. Two cases out of a couple thousand, maybe 1,500. So I think a woman has to be completely insane to falsely allege sexual harassment, because the retaliation, the wave of resentment she's going to get is enormous, and I think women know that. So I think that the workplace itself, because it's dominated by men, dominated by the attitudes we've been discussing, roots out false claims. Women instinctively know that would be crazy. It'd be crazy to reap the reaction you're going to get with a false claim. So I think it's a non-issue. I think it's a shiny object that distracts us from the very serious problem of massive, pervasive sexual harassment. It's so insignificant, in my opinion.
Karen, let me ask you, Neil mentioned consensual relationships, and the ethics of two people in a workplace where, as Justice Long mentioned, there is a power struggle and the power is not even, employee, employer, those types of relationships that choose to want to have some sort of consensual relationship. What do you advise? They probably don't come to you beforehand and ask for advice, right? But
no, but I would
give
say,
us your take of some of the issues. There may be couples married. There may be couples married here that met in the workplace. It is something that does happen. And,
well, increasingly,
hopefully they were single at the
right.
time.
Increasingly, the lawyers would tell you that there are HR firms that now have a policy where you actually have to sign and say, I am having a consensual relationship with so-and-so, and put it in the file, and that's the case. I do think that there's still a stigma to that. I do think that people are still hesitant to do that, but that is an increasing kind of thing that we have seen. I think the biggest question is, someone's idea of consensual may not be someone else's idea of consensual. So the boss's idea of consensual, which is what we hear almost all the time, we either hear it was consensual or I was mentoring her. Those are like the two greatest hits we hear. So your idea of consensual and my idea of consensual are not the same. So our basic philosophy that we share, and it's always too late, is when she works for you, that's not consensual. When you sign her paycheck, that's not consensual. Now, that said, we say if you are looking for unsolicited romance, why don't you go to OkCupid, where you can harass as many women as you want. But if you are going within your workplace, you better be darn sure of what's going on. And to Neil's point, and to Rosemary's is, you know, oftentimes truly what does start as consensual can turn south incredibly easily given the complexities of the workplace today. So for every reason, it is fraught with difficulties. And for every reason, when we do get involved in some of these matters, there is a sense that initially there was some attraction or there was something that was going on that was not incredibly, you know, the women did not object to, or the women were somewhat open, or the women, but it doesn't matter because it is within a moment, it can flip. And that's when, you know, you realize that somebody's really gotten themselves into trouble. That's for when people are both available. When one of them is married, and it is usually the boss, and they are in a consensual relationship, they think, or in a relationship with someone that reports to them, that's when it gets incredibly complicated. And that's when these cases, the first thing we're always told is, I don't want my wife to find out, which is like, it's a little too late.
She's not the
buddy.
one that consented, right? Right, okay.
You know, right. And we've actually, I mean, the craziness is we've actually been asked to even write talking points of how someone could talk to their spouse because a case is about to go public, and they want to know, how should I be able to tell my spouse what I did?
They don't say, Karen, why don't you call my spouse and
No,
tell
but we
them?
want to say, for all of you matrimonial lawyers out there, you're the ones who should be taking that case, not me, right?
Rabbi Yaffe, help us out over here. The power imbalance, employee-employer. What does Jewish perspective, the Bible, talk about the obligations of an employer to an employee and the boundaries that are between an employee and employer to see to it that employees are not taken advantage of in any context? Give us a little snapshot.
Well, first of all, what we're going to talk about, I think you're going to raise later, the boundaries that Jewish law imposes on all unrelated men and women, which essentially are no loaded words, no touching, no being alone in a situation where you're not going to be disturbed.
Sounds like Mike Pence.
What?
Sounds like Mike Pence.
Well, I was thinking you must have picked up some Talmud somewhere, but
He's Jewish. Who knew? Maybe he's Jewish. Who knew?
well, but actually, I should say that these ideas are part of Judaism's universal heritage to the world. These are not matters pertaining to how you pray on Yom Kippur or kosher or so on, which are exclusively Jewish ideas. These are part of Judaism's gift to the world, and part of it is precisely because there exist these type of imbalances. There's even an imbalance of physical strength, right? So there is this concept that you have to create a safe and solid space around you so you can interact with something socially, economically, financially, politically, etc., without there ever being crossed wires that a close working relationship somehow becomes sexually charged. The Jewish law is quite clear that you have to avoid suggestive words, you have to avoid inappropriate looks, you have to avoid, and by the way, because there's a power imbalance, Jewish law imposes this onus primarily upon men. It is incorrect to say that Judaism has this, that there's something about modesty imposed on women. The Talmud in Tractate Bava Batra is explicit that if you think you're going to see women, this has to do with washing clothes. They used to wash clothes by the river, and it took a lot of physical work. The Talmud says, you don't tell them where to go wash their clothes. You take the circuitous route. This is a set of laws imposed upon men and women, primarily upon men, because of the power imbalance. In other words, if there is any sense in an economic business relationship that you're somehow want some kind of intimate relationship out of it, you've already violated the laws. You've already violated the system that Judaism sets up, and not just for Jews, but as good advice to all human beings to avoid these intrinsic imbalances. And there's more to be said, but I think this is a good beginning.
Even if you aren't going to act on them?
What?
Even if you're not planning on acting on them?
Yes, there's a prohibition against inappropriate looking. There's a prohibition against...
How about lusting in one's heart?
What?
How about lusting in one's heart?
One cannot control what comes up into one's heart. If you start building, in other words, you can't control all of a sudden when a shoot of grass shoots up an inappropriate weed grows in your heart. But if you water it and you cultivate it and you coddle it, then you have a problem. Then you have to control it.
We need the pesticide to keep everything under control. We are going to move forward. We're going to move the discussion on, thank you, Rabbi, to non-disclosure agreements. Before we do that, we're going to roll the tape and show a little clip related to a recent ongoing saga impacted and caused, really, by non-disclosure agreements. Please.
A secret. Across the country, at least 6 states have recently proposed legislation to ban or place limits on workplace non-disclosure agreements in cases involving sexual harassment or assault.
This took a lot of work.
And this week, bipartisan legislation was introduced on Capitol Hill that would eliminate forced arbitration, which prevents sexual harassment victims in many cases from going public and going to court. For Juliet Huddy, she says in retrospect, signing the NDA was a bad idea.
The tears are coming because I'm upset with myself for not dealing with it. And again, potentially preventing him from doing something else to somebody.
Very, very powerful, very disturbing on a lot of different levels. Rosemary, the role of non-disclosure agreements, as was mentioned in the video, has changed somewhat over time and is being used in different contexts. What role should it have within the context of doing business, and what's kind of going a little bit too far?
Well, I don't think the role of confidentiality agreements in employment cases has changed that much during the time that I've been practicing. It's commonly used, has been a widespread practice in employment discrimination cases. I think there are two different problems here. A lot of bad things are being attributed to non-disclosure agreements that are not necessarily the fault of the non-disclosure agreements. There is a move federally and in a lot of states to do away with non-disclosure agreements in the current political climate. I think that probably is going to happen. I think it's a mistake. I think that the result of doing away with non-disclosure agreements means that many more cases are not going to be settled. Many more cases are going to be litigated. And you have to understand that the vast majority of sexual harassment cases are not the Harvey Weinsteins and Charlie Roses of the world. The vast majority of them are much more minor incidents of sexual harassment. All sexual harassment is bad. I'm not saying it isn't. But in many cases with lesser accusations, especially when you have a senior executive or a management employee named in the complaint, there's not going to be a settlement if there's not a non-disclosure agreement. If the individual insists and has a reasonable chance of proving that the harassment didn't occur, because he's going to feel like he or she, because sometimes the accusers are men, are going to have to litigate the case out, are going to have to go to trial to clear their name instead of having it on record in the public, on PACER, that they settled a sexual harassment claim. You know, the problem in a lot of the situations where non-disclosure agreements are being given all of the blame is partially something else. The fact that you settle a case involving sexual harassment doesn't mean the employer doesn't have a responsibility to make certain that action is taken against the harasser and that effective steps are taken by either terminating or disciplining or having some kind of supervision within the workplace to make certain that that harassment doesn't continue. Now, that's a separate obligation that's totally apart from the non-disclosure agreement. So the fact that you settle a case with an NDA doesn't absolve the employer from that separate obligation.
But hasn't history shown us that people have stayed in power and continued to reoffend and have kind of used these NDAs as a way to cover up the problems and move on to their next victim?
I think that in some of the examples that we've seen in the news, certainly that has happened. But again, you know, I don't think that we should throw out the baby with the bathwater. I think that the practical effect in the vast majority of sexual harassment cases is you're not going to see settlements, you're going to see people insisting upon litigating their cases through trial. And I think that there are other ways of addressing the serious problem where you've got serious harassers being allowed to remain in the workplace.
Neil, you agree?
No, I respectfully disagree.
Really?
It's a complicated issue. The legislation that's pending in New Jersey, having passed the Senate, speaks of not permitting non-disclosure of the underlying facts, essentially, of discrimination. I disagree with Rosemary that these confidentiality and non-disclosure agreements haven't changed. They have changed. It used to be that we just could not disclose the amount of the settlement. Then they grew broader and broader. You couldn't disclose the underlying facts. Then they grew even broader. We had to turn over the documentary evidence to the other side, or we had to destroy the documentary evidence. You'll see some of these clauses in recent litigation in the O'Reilly case in the Southern District of New York, where the judge revealed these settlement agreements. So they become extremely onerous, extremely oppressive. I agree with the legislation that's pending in New Jersey now in the lower house that would bar non-disclosures of the underlying facts. I think the light of day is essential here. There is a patriarchy. It's not just a phrase. Men dominate corporations. Men dominate law firms. Men dominate the courts. Men dominate the Congress, the legislatures. So how do we break through? We might suffer some bumps in the road as plaintiffs' lawyers. We might not get the settlements we used to get. So what? The purpose the Supreme Court of New Jersey has said of the LAD is to eliminate the cancer of discrimination, to eradicate it. It doesn't matter what happens to the lawyers' bottom lines. That's irrelevant. If we shine the light of day, as is happening again in certain religious institutions, if we shine the light of day, then I think we can begin to eradicate for the first time this massive problem of sexual harassment. It might cause some bumps in the road in litigation. I say, so what?
So Karen, let me turn to you for a second, because sunlight is the best disinfectant, there's no question about that, and it's good for cases to get out and for people to be outed and be called out on inappropriate behavior. But then you have the media, and then you have stories going out into the news which impacts the company, impacts the law firm, impacts whatever group it is that actually are either responsible or may not be responsible for what happened. And what happens to everyone's bottom line then? What happens to the careers of all the people working for you? Is there a place for privacy, for non-disclosure agreements, to avoid certain cases going out into the media, especially in a frenzied environment we find ourselves in, that could literally destroy a company very, very quickly?
Well, there's no doubt that the employees deserve to have their jobs and that they should not have to bear the burden of a CEO or of senior management that was behaving in such a fashion. And that's very important, and obviously that's part of what we get involved with when we walk in, is to make sure that those employees do have a life and that there is going to be a career for them when this is over. That being said, when the media does begin to look at these companies, and the media, I think at this point, has been fairly responsible about reporting on the fact that these are usually not company-wide policies, unless it's a small company where everybody was joining in. These are usually parts of what was going on at the most senior levels of management. Senior levels of management now, as opposed to before, used to be the women were asked to leave. Now more and more, not all the time, the men are being asked to leave. More and more board members are turning over, as we saw in the case of CBS, so that they will now have 6 new board members as opposed to what they had in the past. But that doesn't mean that people are not going to have careers. And in fact, in some ways, sometimes after this is over, this purge, people say, you know what, that's an employer that I want to work for, and it actually becomes a positive, and they're able to recruit people because women feel like maybe I'm going to get a shot at having a career in some of these companies where I didn't have one before.
Could you envision a scenario where an NDA would be appropriate, or where you would recommend a client of yours, you know what, it's not a bad idea to use a non-disclosure agreement?
Well, I think I think even in this law that's being contemplated in New Jersey, it's not that there never will be one ever for anyone at all. I think that on behalf of these victims who oftentimes don't want to have their whole story told, they will have the right to be able to say, I still don't want to have my name out there, I still don't want to be known as that person, and I think that that's what smart legislation is about. But I do think in the case of Weinstein, which was the first time we saw someone break an NDA in a very public fashion, what we saw was everybody assumed, and as even, I know you don't mean to get political, but even with our president who's threatened about, I'm going to go after people, is they're hollow threats. Because once a case is high profile enough and the media's paid attention, when these NDAs are broken, nobody's really going to go after them because that creates just another whole cycle of bringing the story out yet again. But it doesn't take an NDA. I mean, we saw in the case of Eric Schneiderman, he didn't have an NDA with those women, but they still were petrified to come forward. It's about power. It's really not about their legal handcuffs.
Rabbi, let me ask you a question. One of the things you mentioned several years ago when Judge Napolitano was moderating our panel, you mentioned that Jewish law prohibits gossip, and he found that quite astounding. Just in case you were not paying attention, Jewish law prohibits gossip. It's hard to believe. It's not even on our list on Yom Kippur. We're not even thinking about that. That's okay. But there is a concept in Jewish law called lashon hara, speaking ill about someone else and saying bad things about another person, items that are true. One is not allowed to say bad things about another person. It falls under the prohibition of lashon hara. How does the non-disclosure agreement, which seemingly would be upheld by that principle of let's keep this quiet. Yes, the people should be punished for the things they did wrong, but we don't need to go public. We don't need to share bad information about other people. What do you say to people that would give you that argument?
So when it comes to both slander, lashon hara, speaking ill, and confidentiality, Jewish law is essentially in a binary state. It's digital, which means to say, if it's negative about another person, you may not say it even if it's true. This may be where British law got its truth is not a defense against libel thing. Even if it's true, you may not say it. Conversely, if this piece of information, the withholding of it, the not sharing of it could hurt someone financially, emotionally, physically, etc., you are obliged to say it, and you may not remain quiet. The depth, shall we say, of transgression before Yom Kippur, might as well know what transgressions are. The depth of transgression in speaking ill of someone where it doesn't help a third party is equal to the sin of not speaking up where it does help a third party. So that, and the same thing with confidentiality. You don't need an NDA. Under Jewish law, and I know this will come as a shock to everyone, you may not repeat anything someone told you or any information about someone's life that is somewhat privileged without their permission, without any agreement. But if there's a third party involved, you can make all the agreements you want because it's a Jewish law that you cannot make an agreement to create a liability for a third party.
Can you give me a practical example, please?
I was getting there. The practical example is quite simple.
Let's get there quicker, right?
It's quite simple. That if you make an agreement with someone not to share information, that the withholding of that information could harm a third party, it exposes someone to theft, to swindling, to embarrassment, you're not allowed to withhold that information, and the agreements are not worth the paper they're written on under Jewish law.
Okay, perfect. Thank you very much. One last question on NDAs before we move on to our third and final topic for the evening. Someone that's already signed a non-disclosure agreement and someone that's already received their settlement, and now they want to speak up. They're at risk of losing whatever settlement they had or litigating it all over again. What do you recommend? Someone comes to you and says, Rosemary, Neil, Karen, Rabbi, I signed an NDA many years ago. No one knows about this. I don't know what's happened at the company since, but I kind of feel, like the rabbi said earlier, I feel this moral obligation to speak up, but I don't want to have to deal with giving back my settlement. Neil, what do you say?
We honor all non-disclosure agreements we've signed. We've never violated a non-disclosure agreement in our 38 years of practice.
Would you advise someone break an NDA?
I would never advise anyone to do it. I think it's wrong, and we've seen examples of that on the media recently. That said, I want to eliminate non-disclosure agreements. There's a myth out there in the media. That women really want non-disclosure agreements. I can say that we have never had a woman ask for a non-disclosure agreement. I mean, ever. Women don't want non-disclosure agreements. They're surprised and disgusted and horrified when they see the draft of the settlement agreement. It requires them to shut up. There's another issue. It's a moral issue, maybe a Talmudic issue. I don't know.
Well, let's find out. Here
Let's
we
find
are,
out.
right?
Let's find out. And I wonder about this. Because when you have a system like we have now, you're involved in the buying and selling of secrecy. A lawyer on the defense side buys secrecy from me, and we sell it. And sometimes the secrecy involves things the public should know, not just whistleblowers about sexual harassment. I had a case forced into secret arbitration recently involving a medical device that killed 13 people. I made a motion in the arbitration to release it to a plaintiff's firm that had no idea about my case and the testimony. And the three-member panel said, no, arbitration is secret. So we represent whistleblowers about dangers to the public, not just victims of sexual harassment. And yet when these cases settle, there are non-disclosure agreements. So the problem is much graver, as grave as the sexual harassment non-disclosure is. We have whistleblower statutes, and whistleblower cases are being settled in secrecy or tried in secret corporate arbitrations. So is it moral? Is it just for a lawyer to sell secrecy and for a defense lawyer to buy secrecy on behalf of the client? Is there some analog in the Talmud?
Rabbi?
Well, the analog in the Talmud about a medical device that's killing people would be that anyone who creates or participates in such an agreement is an accessory to murder. We don't execute accessories to murder, but they're an accessory to murder. Now let's get back to our topic. In our topic, I would suggest...
Neil, the media will be outside
Rabbi,
at the end of the program.
I didn't hear an answer yet. I heard a partial answer.
The media will be here, and you'll let them know everything.
From the perspective of Judaic law, again, giving that sexual harassment is treated very seriously, in the event that this was not a indiscretion, a weed that suddenly flowered, but it's a whole forest of weeds. It's a whole lot full of weeds, which means to say this is someone who has harassed and will harass again. There's a pattern of bad behavior. Such an agreement may not be made and may not be enforced. Under Judaic law, it's impossible that we should allow someone to keep on endangering the vulnerable, in this case, women in this workforce, under any circumstances. No Judaic law would not allow such an obscenity of this type of agreement to be made in such a case.
Karen, what would you tell someone that wants to break a non-disclosure agreement and risks losing their settlement? What advice would you give them?
So here's the hard, cynical truth, which is in very high-profile cases with very high-profile people, when you break an NDA and you decide to go out there, the risk is less because the media is more attracted and you have protection by being in the media's eye. And unfortunately, it's just the way it works. But if you're going to go out and break an NDA because you're working at a drugstore chain and you're going to go after the guy who was your boss, who was the manager of the drugstore, you're going to get killed for it, and you're going to, they're going to come after you, and you're going to, yes, you're going to lose the money, and yes, there's going to be litigation, and yes, there's going to be penalties because you signed an agreement saying you wouldn't. And it's unfortunate, and it may not be fair, but it is indeed the way the world works, which is why women were allowed, not allowed, but why women that broke it for Harvey Weinstein were able to proceed without being any kind of problem, and why women that broke it for, Jeff Fager, for example, from 60 Minutes, and that's why you don't see it very often. You only see it in those cases, and only, frankly, very recently when there's been enough press attention.
Rosemary, when is it appropriate to break an NDA? Is it ever?
Well, I would agree with the first part of Neil's answer, is that if I have a valid agreement entered into at a time when non-disclosure agreements were valid and enforceable, then I don't think it's valid to break that agreement. I'd like to add that most non-disclosure agreements specifically permit the person to go to governmental agencies, so that you do have, it's not a total bar to disclosing information, because the individual entering a non-disclosure agreement isn't prohibited from testifying honestly. If they're subpoenaed in a proceeding, they're typically not prohibited from going to the Equal Employment Opportunity Commission. They are prohibited from going to the New York Times.
Interesting. Okay, we're going to move on. The rabbi mentioned a weed turning into a forest. So we're going to move on to our third part of the evening, which is second chances and forgiveness, if it should exist or not, and we can roll a tape to a clip that expresses second chances or the lack thereof. Please.
Brooklyn.
There you have a clip of someone who was not given a second chance. Jewish, by the way, right? Abe Vigoda. He passed away, I believe. Is that confirmed? Is that okay? No, never mind. Sorry, I couldn't resist. Second chances. We stand in the synagogue Yom Kippur. We ask God to give us a second chance. We're in relationships where hopefully we say, I'm sorry, I'd like a second chance. Do we believe in second chances and giving people second chances? Does it depend on what they've done? Are there degrees of inappropriate behavior where one would no longer be entitled to a second chance? I mean, you have the Harvey Weinsteins and the Matt Lauers of the world, but you have like Al Frankens of the world and people that have done things that are wrong. Could we even make distinctions between wrong and more wrong? How do we handle this? Meaning, moving forward, we're glad the pendulum has swung, and we hope it keeps swinging, but sooner or later, we as a society need to figure out what to do with the hordes of people that have been thrown out of their companies. Do we believe in due process? What do we do now? And should these people go through whatever process it is and get a second chance? Karen, what do we do with them?
Oh, there's so many ways to go at this question. The first thing to really go at is the hordes of people who are being thrown out now are probably minuscule compared to all the women that lost their jobs through all the years and had to take settlements and had to walk away from their careers. And that's truly the bigger group that no one talks about. Where are they and why aren't they getting back? I mean, even one of Neil's marquee clients, Gretchen Carlson, maybe got a great settlement, but she's not back on the air, and that's really what those women spent their life working for. So I'm not sure that that's the right question, but I will say this. One of the biggest impediments to anyone getting a career back is the way in which they internalize what happened and the way in which they apologize for what happened. And the apologies we have seen across the board tend to be incredibly self-involved. Now I've learned, this has been a learning experience for me, as if these women's lives were really intended to just teach them and how,
it was a mentoring relationship, right? They're mentoring.
We see a lot of the word but, I really am sorry, but I grew up at a different time, but I didn't know that's how she felt, but I didn't understand that that's what I was doing, and that stumbling apology, which is literally, even yesterday we were talking about Jeff Fager. Here he is at 60 Minutes. He has had hundreds and hundreds of people have to give him an explanation of why they did what they did when he did stories about them, and even his explanation was about the worst. It wasn't really that I did something bad, I really texted somebody, that's what this was about. Unbelievable. And when you don't understand what you did to these people, when you cannot identify with the pain that they went through, when you cannot identify where their careers are because of actions you've taken, no, you don't deserve a second chance for that. You have to figure out how to figure out what you've done and where that's gone.
Help us out with apologies. Public relations expert Karen, what's the appropriate apology? How should we be standing in How should we be standing in the synagogue and asking
it's all
for
about
apologies?
you. It's about understanding that what I have done to you, about where your career has gone because of me, what my actions have done to you, my commitment to make your life better, to give you those opportunities that I took from you, or the dignity that I stole from you, or the reputation that I've taken from you, not anything about this has been a learning experience for me, and I'm going to be a better person, and it's all about me, because I don't care about you if I've been that victim.
Rosemary, from a legal perspective, is there any reason not to give someone a second chance? If they've gone through whatever process, they've gone to jail, they haven't, they've lost their job, they've lost their income, they want a second chance, they're not tarred and feathered legally.
It depends on what they've done.
Does it matter what they've done?
To me and how I'm going to advise employers.
Because there are many people, let's be honest for a moment, there are many people, when we talked about criminal justice reform a couple years ago, there are many people coming out of prison that want to get jobs that are having a very hard time doing so because no employer is going to hire someone if there's a little box that says, have you ever been convicted of a crime? And many people want that box to be removed because we specifically want these people to have a second chance.
So I guess...
So do we or do we not?
They're two separate questions here. With your current employer and you've committed sexual harassment, do you deserve a second chance with that employer? That is, you don't lose your job and you get a chance to be a good employee. That depends upon what you've done.
Okay.
There are some things,
Understood.
the guy who drops his pants in the workplace, he doesn't deserve a second chance from that employer. But the guy who gets drunk at a company party, tells some off-color jokes, just enough to cross the line to be actionable sexual harassment, does he deserve a second chance? A lot of times, yeah. He's going to go through progressive discipline, and he deserves it. You know, it's a much more difficult question when we're talking about someone who has committed a crime, in your example, committed a sexual crime, gone to prison or served some other penalty, and then applies for a new job. Lots of states now have very strict standards about considering criminal history in determining whether you're going to hire someone. So that becomes a much more complicated question, and a lot of the people who call for capital punishment for people who commit sexual workplace capital punishment for sexual harassers are
Workplace capital punishment.
Are at the same time very much in favor of the statutes and court decisions that say you can't consider criminal history or only in very limited situations. So that, I think, is a much more difficult.
It's an interesting balance. Neil, help us out here. Second chances, what do we do?
You know, it's a funny thing. About 160 million American workers are at-will employees. They can be fired for any reason or no reason except an illegal, statutorily barred reason. Those are the people we represent. They don't have unions, only 5% in the private sector unionized. They got nothing. A bunch of rich guys assault women, and we're asking about second chances. We're asking about due process and just cause. You know what? Let's get to that topic later. Let's take care of all the women they've injured. That'll take a few decades. Let's make sure Gretchen Carlson gets a job in the media. We don't have industry retaliation, which is she's suffering right now. Let's make sure all the women who have been assaulted, settled, and then after they settled, they had to leave work, hire them back. Hire them all back, all these women that had to settle and leave while the men stayed. And then when all that's done, and by the way, we give everyone the right not to be fired except for just cause. Then let's talk about these rich guys. They're not suffering like Abe Vigoda. They're sitting there with their millions. They're doing okay.
Rabbi, Jewish law, when it comes to second chances, to rehabilitation, does it matter what the crime was? Would you put someone back in an environment where they could possibly reoffend? I mean, everyone can possibly reoffend. What do you do? Give us some Talmudic wisdom here.
There are several issues.
10 minutes left, folks. 10 minutes, we wrap the program
There are
up.
several core issues.
Got my watch. We're good.
There are several core issues. Number one, several of our panelists have addressed the question of sincerity of apology. I found what you said fascinating because under Jewish law and Maimonides and the Code of Jewish Law, the formula, you have to mean it, but the formula is not, oh, I messed up, oh, I had a bad childhood, oh, I drank too much. It is, I have sinned against you and I hurt you and I feel regret for it and please forgive me. It's all about the victim. That's number one. Number two, we are obliged to forgive those who seek forgiveness after they've paid us the appropriate damages and so on, but only if it's sincere, even if they pay the damages. If there's a sense that it's self-serving and not out of a sincere sense of the bad thing that they did to us, not out of a sincere sense of regret that they hurt us, rather than, oh, I want to get back into my job, so we're not obliged to forgive. And certainly if the victim isn't, if the apology and the change in the victimizer is such that the victim is not obliged to forgive according to Jewish law, all the more so we shouldn't be giving them their jobs back or a similar job. That's number one. Number two, there are many cases in Jewish law, it's in the Talmud, in the codes, where someone violates the public trust or the trust of a group of people who might be the public and so on. We do not say, oh, this person apologized because they were found out and paid back what they stole or what they swindled. When the person goes, lives somewhere else, or goes, does something else for a living, and we see that they return a lost object, that they lost money, they act honestly, they engage in a selfless act that costs them money for no benefit to themselves, then we might say this person has changed.
They have to show they're sorry
Right,
instead
they
of say
have
they're
to show
sorry.
that they fundamentally changed without an eye to the cameras. But it goes further.
Not just a soup kitchen on Thanksgiving, that's not good enough.
Precisely.
Okay.
I always say all the people who show up to feed people at Thanksgiving think that poor people have different biology than everyone else. Everyone else needs to eat every day. Poor people need to eat once a year. You know, but what's really happening here is another thing. That we say that if, let's say, you know, you weren't that religious and you ate the odd pork chop, and then you become religious, you only eat kosher. So someone who's always ate kosher their whole life can say, you know, I'd love to eat a pork chop, but God told me not to. But someone who's already who did it and now doesn't, shouldn't say that because they actually know what the pork chop tastes like. And the point being that we don't put a person in a position where they have tasted the forbidden fruit, they've gotten away with it, and if there was a long pattern, we say, look, we'll give you another job, but we're not going to let you have this kind of power or do this, because this is also the idea of not placing a stumbling block before the blind.
Not going to let you handle the company barbecue, right?
Right.
Okay.
Yeah. And for that matter, we don't. You know, for that matter, you know, someone who has an alcohol problem, you don't make them in charge of a liquor store,
So you have to
and
be
so
careful.
on.
Understood.
Last of all, the last point of all this is the benefit of the public. You know, a priest, when the temple was standing, a priest who killed someone, even accidentally, and regretted it and went into exile, did all the things you have to do for manslaughter, can never ever serve on the altar again. Because the public cannot see that someone who took another life should now seek to atone for us and give us life. The priest can do a million other things. He can't do this. So I would say that there are many cases where we need to make it clear that this abuse and this exploitation is so horrendous that you cannot be in charge of other people ever again.
Well, that's why we have such a high bar for who can qualify to serve in public office. Right. Did everyone here, by the way, I have to throw this in, if anyone saw the eulogy that Joe Lieberman gave for John McCain just last week, so he said over one of John McCain's favorite jokes, which was, there were two inmates in a state penitentiary who were standing on line waiting for dinner, and one turns to the other and says, you know, the food here is really terrible. And the other one says, yeah, it was much better when I was governor. Which goes right back to the point of public trust. Last thoughts, let's start with Rosemary. Give us a minute, your thoughts on the topic, where we've come as a society and where we're looking to go moving forward.
Well, I think that we've come a long way in dealing with sexual harassment. I think that the business community today, as a general matter, has either achieved or is working very hard to eliminate sexual harassment in the workplace. I disagree with a lot of what Neil has said about the extent of sexual harassment and the seriousness of sexual harassment. Yes, there are too many serious cases that we've seen in the news, but there are a lot of the other litigation that we see involving sexual harassment involves much more minor allegations and does involve some false allegations. So I think that in moving forward and continuing to strive to have workplaces that are free from discrimination and harassment, we have to make sure that we maintain principles of due process for both the people making the allegations and the people against whom the allegations are made, because some of them are true and horrible and some of them are not. We also need to make certain that we don't see the pendulum swing too far in the opposite direction. We have a horrible history going back many years of permitting sexual harassment in the workplace. We're moving away from that, which is a wonderful thing. We don't want to go so far in the other direction that we've eliminated all rights of people who are accused of sexual harassment. We need to find a middle ground where it is legally required and good business to maintain a workplace that respects the rights of all of its employees. I think we're headed in the right direction, both in terms of our statutory law, our cases, both in New Jersey and in the federal courts, and in the requirements that virtually all well-meaning businesses are imposing on themselves and the other businesses they do work with.
Thank you, Rosemary. Neil, last thought.
I think I disagree. I think sexual harassment is pervasive.
We know you disagree.
I think we're in the middle of a backlash. There was a backlash after the women's movement surged in the 1970s. There's a famous book called Backlash. I think the CEO of our nation is part of that. And I think you can see the ugliness of misogyny and that it is pervasive in social media. And I think the legal mechanisms that we have are good, but not adequate. And so when legal mechanisms fail, when victims are forced into secret arbitrations and non-disclosure agreements, it spills over in the form of the Me Too movement, just the way the civil rights movement hit the streets when the courts failed them. To the extent the courts require mandatory secret arbitration and corporations demand non-disclosure and confidentiality agreements in these matters, they are forcing women into extra-legal activity, like the Me Too movement and some of the demonstrations we've seen. And I think it's important for the legal community to respond with much better than we have. Thank you.
Karen.
You know, it's a hard topic for employers to talk about, and that's exactly why employers should be talking about it more and more. And until people feel comfortable addressing this, talking about it, explaining that it's not okay, that that's not the culture of our workplace, there's always going to be those people that are going to assume that they're going to be able to get away with it. And while the words may be tough, and that just means there needs to be more teaching, there needs to be more training, and there needs to be more leadership from the top. And to quote my friend Ginny Long, and until those boardrooms and until that senior management begins to look a little bit more diverse than it does now, or a whole lot more, it's really only going to be incremental change.
Rabbi, last word.
We've heard a lot about legal remedies, agreements, lawsuits, protests, but in the end, the approach of Judaic law and thought has to do with the cultivation of decency within the individual. Jewish law is not couched in you not ought to victimize the person in this way, that this person ought not to be victimized. It's couched in the terms that you ought not to look at a person as a sexual object. You ought to control how you see. You ought to create the boundaries so you can have a respectful professional or social relationship without getting your own wires crossed, even in the primitive male mind, because usually it's the men who are the offenders. You need to make sure that you are not in a position where you could act on your worst impulses, because you're never alone with someone who you shouldn't be. You're never looking at them a certain way. You're never talking to them a certain way. Professionally, whatever you need to do, you do, but you don't. And Jewish law seems a bit draconian. Many opinions in Jewish law suggest no touching at all.
At all?
Certainly nothing more than a handshake for those who permit it. But you know what? If you're never alone, you never touch, and you never look at a person as an object, but you look at them as a human being who you're interacting with, and that intimacy is negotiated from our perspective, hopefully with the hope of a long-lasting marriage. Sorry to all the divorce attorneys in the room. That's our vision. And the vision begins with the education of the individual. We need to talk less about what you ought not to do to the other and think more, what kind of person should you be? And how do you live with yourself if you're not that person? Because if you don't see the image of God in the other human being, you clearly don't see it in yourself. And why do you want to live with such a person every day?
Thank you very much. Okay, folks, 8:29 on the dot. I want to thank our panel very, very much. I want to thank Rosemary and Neil and Karen and Rabbi Yaffe. I want to thank Justice Long for her brilliant words. A couple of quick announcements. First of all, there are 3 exits to the building. You don't need to go out the front. You could go back around the back of the building. Please leave your name badges at the front so we can reuse them next year and be green. Please take a challah on your way out, and please have a happy, healthy, sweet new year. There will be a minyan for Meir of the evening service outside in the lobby, right out here. Happy, healthy, sweet.